Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Is Johnathan Majors being railroaded in New York City? Let's explore that, and you can tell me what you think in the comments. No matter who commits it, domestic violence is wrong. Today we're going to look at the trial of Johnathan Majors in New York. We're going to look at it carefully, but without the video, since the trial is not being streamed. New York is one of those states that does not stream trials. Men in this country have, unfortunately, a long history of being physically violent with women. There are statistics that say that in many cases the violence against women increases exponentially around the holidays and especially at times of Super Bowls. In the past 20 years or so, domestic violence has become a hot-button issue. So has the issue of race. And in many parts of the country, people still remain judged by the color of their skin, and women still don't get paid what they're worth. Both of those things are wrong. The question is, when race and domestic violence mix, when those two issues present themselves together, how do we separate them and how do we analyze them? Well, two things can be true at the same time. First, it's wrong to abuse anyone, and especially someone you claim to love. Second, it's wrong to use anti-abuse laws when you start the fight and when you're the one making the false claims of abuse. I want to get out there up front. I am no fan of men abusing women. But I'm also no fan of the Amber Heards in the world out there who believe that this is a ticket to fame and stardom and maybe a little extra cash for the holidays. I believe the worst wrongs you can commit are to falsely accuse someone of something that you know they didn't really do. Now, I'm no fan of Hollywood. I find it a place where people have way too nice a view of their own importance. They think they are much more important than they are. And I think generally a lot of Hollywood types think that the law doesn't really apply to them. So I don't bother learning who's hot in Hollywood, what roles they have, or any of that. If you're clueless about who Johnathan Majors is, like I was, let me give you the TLDR here. Johnathan Majors has been in numerous films. He is an African-American actor. Recently, he was in Creed 3, and Marvel had him tapped to play Kang the Conqueror in some of their upcoming films. Then Majors and his now former girlfriend Grace Jabari had a row, and they accused each other of assault. The cops believed her and not him, and Hollywood has Johnny Depped Mr. Majors. Now, Majors has denied the allegations that he abused Jabari, and the district attorney declared that his allegations against his now ex-girlfriend lacked prosecutorial merit. In other words, Johnathan, we don't believe you. He's charged with misdemeanor counts of assault and harassment. And he could face a year in prison, but that's unlikely given his lack of a criminal record. It's probably likely he'd get probation. Majors was arrested March 25th in New York City on allegations that he choked and assaulted and harassed Jabari. He pleaded not guilty to all counts and accused Jabari of attacking him. The trial has been fodder for the exploitative nature of modern journalism. It's been revealing private moments between the couple, essentially relying on evidence of past misconduct to assert that that's proof of the current misconduct or current alleged misconduct. At the heart of the assault claim is an incident where Jabari grabbed Major's phone after seeing a text she believed was from another woman. The text allegedly said, "I wish I was kissing you right now," or something to that effect, according to the prosecutors. Now, when you reach across a vehicle, which is where they were, and grab a phone out of somebody's hand, that's assault. There's no way around that, and she has pretty much admitted that she did that. But of course, that doesn't have prosecutorial merit. What does have prosecutorial merit? Well, Majors supposedly responded by pulling her finger, twisting her arm behind her back, and striking her face in an attempt to get the phone back. That's what the prosecutors say. But given this set of facts, it would certainly appear that the initial aggressor was Jabari. They were being driven by a driver who stopped the car. Majors got out, and Jabari grabbed onto him, not letting him go. He tried to push her back in the car. The defense attorney said, well, he was just trying to protect her from oncoming traffic, but there really was no traffic at that time. Mostly what he was trying to do was rid himself of a tick. And the tick kept coming back and grabbing a hold of him. And that's what the video shows. There is a video here on YouTube. It's Adonai Publishing, Adonai Publishing, that has the video, and I recommend you watch and listen to that discussion of it. I think it makes the defense case pretty well. I will link to that in the description. Suffice it to say that the video demonstrates that Jabari pursued Majors, and Majors was running away. In fact, she chased him for several blocks down the streets, at one point almost being hit by a car because she wanted to catch up to Johnathan Majors. He was a bit faster on his feet than she was. At trial, however, instead of limiting the evidence to the events of that night, the court has admitted a plethora of evidence of prior alleged but essentially unproved misconduct. In her testimony, Jabari said she feared Majors, but that she also worried he would harm himself. She says she believed he used the specter of self-harm to manipulate her. Let me just pause at this point and suggest to you that no Hollywood actor is going to engage in self-harm and have himself a little pity party and hurt himself in that way. I think that's kind of ridiculous. But there are some texts that essentially back her up on this, and that's also fair to note. But she says she believed he used the specter of self-harm to manipulate her. Her belief is not evidence. It's lay opinion. And it should have been excluded unless she could demonstrate that she is an expert, which I doubt that she can. So that, to me, right there is probably good enough to merit a reversal in the case, assuming the case gets appealed. But here, juries heard Major's 911 call to report Jabari, and he thought she might have tried to kill herself because he found her passed out in his closet. They saw photos taken by Jabari following the incident that showed dark bruising on her finger and a cut behind her ear. The jury saw text messages between the two, with Majors stating in the hours after the incident, "Maybe I'm such a monster and horrible man that I don't deserve it," meaning love, "and I should just come on now." In the same group of messages, Majors expressed a hope that Jabari would not seek treatment for the bruising and laceration because it could lead to an investigation. These messages in the days and hours after the supposed violence were absolutely fair game. Here's what wasn't fair game. Prosecutors used Majors' own words against him. The three-man, three-woman jury heard Majors tell her that he needed a partner worthy of Martin Luther King Jr. and Barack Obama. And then he blamed Jabari for having shortcomings, and basically Jabari recorded this without his knowledge in London in 2022. So they are bringing in stuff that happened in 2022 to prove something that has absolutely no relationship with what happened on that street in New York City in 2023. The recording said, "I'm a great man doing great things. The woman that supports me needs to be great women. They need to be great women, and they need to make sacrifices." I think actually he said the woman and not the plural of women. Although, again, I'm working from secondhand sources here. Now, I want you to think about what evidentiary value the statement, "I need a woman like Michelle Obama," or like the wife of Martin Luther King, what value does that have in proving the assault? How is that relevant? It might be relevant to whether or not they should get married, but it isn't relevant to the assault. And the only purpose that that evidence can have is to diminish him in front of the jury. And you have to remember that the accuser here is white. Mr. Majors is an African American. It is an unfair use of race against the defendant. And here's something else. It led to retaliation by the defense counsel, who essentially said, now we know what happens when an African American man in the United States calls 911. He winds up in jail. I think that has some resonance as well. But the real question here is, how did that get into evidence? I just do not understand what the value of that evidence was in proving the assault, because otherwise it should have been excluded. It's just a bad person, bad character kind of assertion. And I also think it's racially motivated. I could be wrong on that, but that's what I think. And I think anytime you use race as a weapon, you should be ashamed of yourself. According to observers, Majors sat kind of glum in the courtroom as texts between him and Jabari were read, and one of them said, "I will tell the doctor I bumped my head if I go." She wrote about plans to get painkillers from a hospital in London. Majors wrote back that going to a hospital would lead to an investigation even if you do lie and they suspect something. So it's pretty clear he didn't want an investigation, and of course he had a reputation to protect. Now, in many other states, those texts would not have come in. Most states apply the rule against uncharged bad acts. In fact, here's what the rule from the federal court says. Other crimes, wrongs, or acts. Prohibited uses. Evidence of any other crime, wrong, or act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with the character. Permitted uses. The evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Notice, in a criminal case, the prosecutor must A. Provide reasonable notice of any such evidence that the prosecutor intends to offer at trial so that the defendant has the fair opportunity to meet it. Articulate in the notice the permitted purpose for which the prosecutor intends to offer the evidence and the reasoning that supports the purpose. And C. Do so in writing before trial or in any form during trial if the court, for good cause, excuses lack of pretrial notice. Now, here is what the New York rule says. Evidence of crimes and wrongs, Molyneux. Evidence of crimes, wrongs, or other acts committed by a person is not admissible to prove that the person acted in conformity therewith on a particular occasion or had a propensity to engage in a wrongful act or acts. This evidence may be admissible when it's more probative than prejudicial to prove, for example, motive, opportunity, intent, preparation, common scheme or plan, knowledge, identity, absence of mistake or accident. And here's where New York adds to the federal rule, or conduct that is inextricably interwoven with the charged acts, or to provide necessary background information or explanation, or to complete the narrative of the subject, event, or matter. In a criminal proceeding where a defendant interposes a defense, which is all of them, the people on rebuttal may prove the defendant's commission of other crimes or wrongs when such crimes or wrongs are relevant to and probative to disprove the defense. And in New York, the defendant is not entitled to any pretrial notice at all. So essentially, this can be sprung on them at the time of trial. Having seen the video and knowing the video doesn't tell the whole story, I can understand letting the victim testify that this wasn't his first rodeo, and it wasn't the first time things got physical. But I have a problem with the amount of evidence of prior conduct when it is offset by the actual video. In other words, if you are trying to prove that on the night in question when he was in New York City, where New York has jurisdiction, he did the things that he's alleged to do, evidence from a year ago in London is not good evidence. For her part, the lawyer defending Majors put on a good defense. She noted that Jabari went to a nightclub with a group of strangers after the incident and, quote, had a ball. There she is at the bar selecting champagne. There she is doing shots, all with her right hand, which of course is the one that she's supposedly injured. The lawyer replayed video of Jabari walking back to Majors' apartment building where police found her the next morning lying on the floor of a walk-in closet after Majors called 911, thinking that she had committed self-harm of her own. Here's what the lawyer said. This whole trial has been about what happened in that car, even though the people want this trial to be about arguments from months and years ago. That's because what happened in the car is obvious. The real mystery is what happened after Grace got home. Now, I would point out that one of the witnesses in this case was the driver who was driving that car. And his statement was that the woman was all over Majors and that Majors was trying to get rid of her, that he was trying to push her away, basically to distance himself from her, ostensibly because she was hyper emotional at that point. When he testified in that manner, the prosecutor put him on as a witness. And when he testified in that way, the prosecutor rebuked him and said, keep your opinions to himself. Except that really wasn't opinion. And the reason it wasn't opinion is because he was describing acts and actions that indicated this. He was pushing her away. He was trying to get away. He was describing his conduct, not his belief about what happened. So I think that's an indication that the prosecution probably knew that their case was fairly weak. Well, here's my problem with this case. Justice is supposed to be process-oriented. The state and the judge are supposed to follow the process to get to the right and just result. They are not supposed to bend the rules because there's a pretty woman with a good story to tell. Now, I'm not saying that's what's happened here, because maybe it isn't. Maybe when he's expressing remorse for looking at that text from another woman and saying maybe he didn't deserve love and saying maybe that he ought to commit some self-harm here, maybe it does reflect on his mental state and maybe he is a monster. But I have a major problem, no pun intended, with admitting the prior uncharged, extraterritorial bad acts. The exceptions from the New York evidence rule do not in any way wash, and, more importantly, as a matter of policy, they are designed to swallow the whole rule. What prosecutor couldn't make a case that what happened a year ago is inextricably interwoven with the domestic violence allegations from today? What prosecutor couldn't make an argument that it's necessary to provide background to know what the length of their relationship is? Again, it is an exception that swallows the rule. It's bad public policy, but it is, unfortunately, very consistent with New York law in other areas. New York law is not very defendant-friendly. I have a huge problem with that aspect of the case. I don't think it's necessary to provide background because the victim could provide that. And it also doesn't complete the narrative, again, because the victim did that over 3 days of testimony. Now, the jury has already deliberated a long time on this case. There are 3 men, 3 women. That's an interesting mix. They could very well be stuck with the men all voting to convict and the women all saying, let's wait up here, just a minute. This does not look like a woman who has been harmed. And the worst part is, with all those texts and messages and evidence and released to the public, the damage to Majors' career has already been done. Even if he's acquitted, he will get to experience what Johnny Depp experienced. Now, maybe he's a Hollywood type who thinks the rules don't apply to him. I don't know. I just know that reading about this trial made me wonder about the judge's discretion in admitting that evidence. His job is to ensure that Majors gets a fair trial. It isn't to ensure there is a conviction. I do not see how anyone could watch that woman chasing him down the street, running after him, darting in front of cars, and then allow that evidence in just because it helped the prosecution make its case. In case you're wondering, I side with the defense here. I saw the video, and, a video doesn't necessarily tell all the story, but in this case, it tells a lot of it. For that reason, I side with the defense here. Let me know your thoughts. I'm always amazed by my subscribers and their takes on things. I have learned so much from all of you about the Adelsons, for example. I hadn't heard of the Adelsons before I saw the Charlie Adelson trial. But there are a lot of people with a lot of institutional knowledge who had absolutely no problem jumping up and correcting me. Something I appreciate because I want the full story out there on my channel, and I think it's important for people to comment when they know the other side of the story, or they have something that amplifies my opinion or my belief. Either one of those two is fine. So if you know facts that go one way or the other in this case, let me know in the comments below what they are. Tell me what I'm missing. It's that time of year, a season of brotherhood. Remember, kindness is never repaid, it's only passed on. So if someone has done you a kindness during this season of brotherhood, please pass it along. Do something nice for someone. And then return tomorrow and catch me down here at the beach. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.